Looking at the merits, there's no causal connection. The inspector admits he did not have any suspicion of money laundering. He thought the proceeds were derived from 14 Chinese being trafficked. There's nothing to show that these people are being trafficked in any event. But that apart, what the application said, was that this was money that was seized by the police, then re-seized by the F.I.U. Which re-seizure by the F.I.U.? It was always the one seizure by the inspector who sent for the F.I.U. and afterwards gave them custody of the money. But it is his seizure, there is no re-seizure. So the F.I.U. is completely without any remit to bring this application. And even if that is not so, you can't bring it more than 72 hours after. You can't hold the cash for more than 72 hours. They tried to get around it by suggesting, well, the F.I.U. re-seized when it was handed custody at 9 the night, which would perhaps bring the... No, you heard I was the one who seized, and I seized at 8 and 9 a.m. They got a report from the tax people dated what? Today is the 17th, maybe midweek last week. Remember, their application can only succeed if it is within time and if the original seizure was lawful. It could only have been lawful if the inspector reasonably suspected that the money was the proceeds of tax evasion or was accumulated because they were hiding taxes, was in some other form money laundering. You've heard him say he had no suspicion of that sort. So how you will bring that in now? You develop a suspicion after the fact based on some report you get from the tax services? No, that cannot be contained within the four corners of this application, premised on what the position was at the time the inspector seized in order to show that it was a lawful seizure.